On behalf of Financial Police, thank you to everyone joining us today. We are glad you're here. We'll talk about the nuts and bolts of lost profits cases with our panel of Megan Beckwar, Matthew Blumenstein, and Nancy Bello. Before we get started and we delve into our conversation over the next hour, a few administrative housekeeping things. Today's program is co-sponsored by Financial Poise that provides education for attorneys, accountants, business owners, executives, and investors. It's also co-sponsored by the National Law Review, a legal news website with analysis on a wide range of legal and business topics. A brief disclaimer, our panel, we are here today to offer insights, but it's not regarding any particular case or particular matter. So if you're looking for specific advice, you should obtain your own legal or expert or professional advice. Nevertheless, you will have the slide materials and feel free to reach out to any of our speakers. The contact information, their emails are in the deck. Now let's meet our faculty. Our faculty today includes Megan Beckwar. Megan is the founder of Dispute Economics in Philadelphia. She has expertise in business valuation and forensic accounting. Our panel also includes Matt Blumenstein. Matt is a principal of Statera Capital here in Chicago. He's a litigation funding and financier specialist. I am the moderator, John Levitsky. I'm with HKA. I'm based in the HKA Chicago office. I handle forensic accounting, commercial damages, and business valuation expert work. And in addition, we have on our panel of speakers, Nancy Bello. Nancy's an experienced business litigator. She also has quite a bit of experience with restructuring and workouts. Today's program, we're going to focus on lost profits. And as you're probably aware, this is part of a series of programs by Financial Poise. This series is on the general topic of complex financial litigation. Today's program is the second in the 2026 series. There are 2 additional programs upcoming as well. And at this point, we're going to dive into our program. We're going to hear directly from our speakers. The goal was to have a lively, topical discussion, and we're providing the slide as background materials for each of our attendees to download or otherwise access electronically to take notes on if you'd like. They're there for reference material. But today we're going to hear live from our speakers, and the slides are there for your additional information. So with that, what are we going to talk about? We'll talk about 5 general categories with our panel of 3 speakers. First, we'll talk about a general overview of lost profits. Second, we'll talk about some of the proving lost profits, some of the proof issues. We'll talk about the role, ROLE, of experts in these types of cases. We'll also touch on general, well-considered, often accepted methods for calculating lost profits, depending on the facts and circumstances. And then in the closing minutes, we'll talk about the other side of this, some of the common considerations in potentially defending against a lost profits case. So we're basically looking at situations where there's been a disruption, maybe a destruction, maybe an impairment. There's some claim along those lines, and we're going to focus on the economic and financial aspects of lost profits. So with that background, Nancy Bello. Nancy, could we start with you instead of stop? Could we start with you? And would you help us understand what are lost profits? What's a basic definition, and what types of cases are involved from a legal perspective?
Sure, thank you for the introduction. Lost profits are the economic damages that are caused by a disruption of a business. At their core, they represent the revenues that would have been earned but for the wrongful act, less the incremental costs that are necessary to derive those revenues. So, for example, Imagine a restaurant owner has a contract with a food supplier to deliver fresh produce weekly. The supplier breaches the contract by failing to deliver for 3 months, forcing the restaurant to close temporarily. The restaurant's lost profits would be the revenues it would have earned during that 3 month period, minus the expenses it would have incurred to operate. So, for example, cost of goods sold, labor, utilities. The goal of the lost profits damages is to put the restaurant owner in the same position that it would have been in, but for the supplier's breach, but not to give them a windfall, just to make them whole. So some examples where this lost profits may be appropriate: breach of contract cases, liability due to accident or damage to property, intellectual property infringement, or trade secret misappropriation, or unfair competition, tortious interference, or the like.
Well, thank you. Megan, so from a valuation and financial and forensic accounting perspective, what's the difference between lost profits damages and other types of damages? And are there maybe some business scenarios you could help us to understand this? And also, is there something that experts consider to avoid double counting if there's more than one potential type of damages?
Sure, thanks, John. Where it comes to double counting, the scenario where you'd most commonly see that erroneously occur in a calculation is where there are both lost profits damages as well as a business destruction damage claim. So the difference being, in business destruction, there is no ability to fully recover from the loss. So it's considered losses that will continue on in perpetuity, and it's measured in terms of the value of the business. There could have been a time period, however, that the business was, damaged in some way. There was an interruption that caused it to operate at a lower capacity for a few years. And then ultimately, they just couldn't sustain themselves and had to shut down. So in order not to double count, you would look at that past period as lost profits, and then the future, basically, expectation of earnings, which converts to the value of the business that's lost.
Well, thank you. So Matt, from a perspective of proof, are there some key elements that tie with the legal claim that need to be established for a lost profits case to proceed?
Yeah. In a word, yes. As always, you want to consult the case law and other authority from your jurisdiction. But if we're speaking roughly in the aggregate, you commonly see the necessary components or elements or prerequisites for lost profits recovery being causation, i.e. the wrongful act caused damages, caused lost profits, foreseeability, which sometimes can be conceived of as a sort of aspect of approximate causation, but nonetheless, foreseeability, that it was foreseeable to the defendant that this sort of wrongful conduct, this breach or tort or what have you, would engender lost profits. And then you have to prove lost profits to a degree of reasonable certainty. It's a relatively, in my view, it's supposed to be a relatively permissive standard that you'll regularly see courts say that you don't need to have absolute certainty as to the quantum of lost profits, which is fortunate because it would be we're talking about sort of counterfactuals here, so it'd be quite difficult in many cases to have anything higher than a sort of reasonable certainty. So those are typically the three prerequisites that you see, or elements that you see articulated in the case law.
Well, thank you. Nancy, are there some basic considerations in terms of what kind of evidence of, if we're on the coming in hypothetically from the plaintiff's side, that they may want to consider as to whether they have evidence of lost profits? What might they be looking to see if they have?
Sure, there are a few different types of evidentiary support. One is informed opinion. So the owner or the expert witness would testify based on evidence of past experience of the business, or provide testimony that's sufficient to quantify the lost profits. A second type is judgmental approximation. So here, the plaintiff's owner can provide evidence of the company's past experience in situations where the owner has substantial knowledge. And then additionally, there's credible evidence, which could include industry averages, governmental information, or official statistics. But note that for this type of evidence, you have to consider how you can get the non-company specific evidence into the record, which sometimes can be done through an expert witness. So the general rule in Texas, for example, which a lot of other jurisdictions follow, is that recovery of lost profits will be allowed where it's shown that the lost profits are a natural and probable consequence of the act or omissions complained, and the amount is shown with sufficient certainty. This is known as the sufficient certainty test. So sometimes a business owner's testimony by itself is not sufficient, but in certain cases, it can be, but the owner would have to show which specific contracts were lost, how many contracts were lost, how much profit they would have received. But it's not mathematical precision, just reasonable certainty.
Matt and Megan, are there some additional observations from your perspective you'd like to add on what type of evidence might be appropriate to demonstrate a lost profits case?
Go ahead, Matt.
Well, as always, it depends. And I think we're going to talk about various sort of different scenarios that can arise, wrinkles within this, doctrine or area of the law. But one that's interesting to me that always occurs sort of first is the difference between a new business and an old business. An old business, you might have, to pick up on Nancy's hypothetical, you know how much the restaurant was making the previous January, or the previous February, or the previous March, and maybe there's some confounding figures, but you can generally have a track record to point to for revenue and for costs. So it's simple enough to determine what the lost profits are. But what if it's a new business? What if it's, the hot new chef? You paid a fortune to stand up the hot new chef in the cool neighborhood of Brooklyn, wherever that is these days. And the investors are very bullish and everybody's very bullish. And then the contract is breached and you go to court and you say they didn't deliver the produce and we couldn't open the restaurant and we lost all this profit. Well, how do you prove what your lost profit is in that instance? And that's where that becomes more challenging and more interesting. My favorite, in practice, my favorite kind of evidence to see in a situation like that is when you have the defendants making projections about what the profits are going to be. That can oftentimes be helpful in getting over this argument that was purely speculative. The defendant's favorite phrase in this context is always speculative. They say early, often, beginning, middle, and end. This is all speculative. And if you have the defendant's own documents projecting what the profits, what the revenues, what the costs are going to be before they messed everything up, then that's a nice way of fending off this claim of being unduly speculative. So that's one example of evidence that I like to see. Although, frankly, in a new business scenario, lost profits is always a little bit of a tough nut to crack, in my view. I don't know how you feel, Megan.
Yeah, I think that having the defendant's own expectations is excellent starting point for a projection for a new business. Another potential source of information would be if the plaintiff has provided projections to a lending institution and the the bank lent the money on those representations, that at least that's another third party. These were contemporaneously produced projections that don't relate to litigation, and somebody believed them. So, that does add to the credibility for a new business. From an existing business standpoint, you really look at the lost profits similarly to you as how you would value the company. So you start by understanding how it operates. You look at its historical performance. You try to identify trends. You're probably going to want to interview management and kind of glean information about specific expenses and cash flow, timing, and things like that. Sometimes when you're on the defense, you don't get access to the business owner, and you have to try to glean that information from interrogatories and depositions, and that does make it a little bit more difficult. But nonetheless, you put all of that information together and come up with what the expectation would be, assuming you don't have projections to look at, and you need to just gauge it against the industry and economic activity that was occurring or is expected to occur, depends on your damage period. And then basically you try to consider as many information sources as you can, because in order to build a credible view of the future, it's always best to try to triangulate. We call it that in valuation analyses, but you're looking at least three, data sources if possible.
Well, so thank you, Matt and Megan. Historical results versus what occurs during the period of alleged lost profits. Is there always consistency between the historical period and the alleged lost profits period? Or is there sometimes a significant difference? And Nancy, are there some legal case examples that come to mind where courts have addressed this?
Sure. As a general rule, past profits could be helpful to establish lost profits with reasonable certainty. But there are situations where courts may exclude or discount the past profits evidence when the circumstances have materially changed between the historical period and the period for which the damages are claimed. So certain examples of this could be if there have been significant shifts in the market or competitive landscape, if there have been changes in the plaintiff's business model or product line or customer base, if there have been regulatory changes in the industry or economic downturn or other macroeconomic factors. We've also seen cases, well, the new business, that's another good example where, there is no there's no profit history, but it may not preclude a new business from recovering in the future for future profits. But it has to be, you need some additional specific evidence to show why, to show the evidence of the future profits without being speculative, as we discussed. I actually have a good case that addresses the speculative issue. It's called Capital Metro. It was a Texas case where the company had a history of losses and was actually awarded $1.5 million in, well, let me back up, sorry. There was a canceled contract between Capital Metro and Longhorn Railway Company, so a company in Austin, Texas. So the jury awarded Longhorn $1.5 million in lost profits, and Capital Metro appealed. And the only testimony offered at trial was regarding lost profits came from Longhorn's expert. And the Court of Appeals held that the lost profits had not been proven to a reasonable degree of certainty because the expert calculations were based on the owner's speculative assertion of the number of contracts the rail line could have potentially handled without additional evidence of the reasonableness or reliability of the assumptions. And the court also noted that the company had a history of losses and there were no contracts to support the increased revenue the expert claimed that Longhorn would have going forward. So therefore, the expert's testimony was all based on unfounded assumptions, and it was insufficient to establish lost profits with reasonable certainty.
Well, thank you. Megan, what about unusual time periods that are within the historical base period, like 2000, 2001, when there was the COVID pandemic, or maybe it's last spring during April when tariffs were first announced and the stock market and the bond markets had some increased volatility. How do you, in a lost profits situation, if you're comparing a base period versus the current period where there are alleged lost profits, how do you deal with that?
Well, hopefully you have sufficient historical data to look back to that you can just eliminate 1 year or 1 month or whatever it is where you see that there's an obvious anomaly. You try to use a normalized level of operations to forecast the future. But if you don't have a sufficient amount of historical data, then this is another situation where you have to go out and find an alternative source, or you're going to at least sanity check against an alternative source. So you try to find other industry participants, longer standing historical activity, or something else to measure against so that you can try to project the future without having to consider an anomalous period.
Might that also affect the expected growth rate? In other words, if you came from a trough or a dip in middle of 2020 and the demand in a particular industry, and now you're looking at lost profits that allegedly started a couple years later, if you were comparing historical growth, you might see a positive trend, but maybe that positive trend would flatten out once we're past the COVID pandemic. So there's some growth rate considerations as well.
Yeah, absolutely. I mean, you'd almost have to just normalize that period, assuming that COVID or whatever the case may be didn't occur, if you need to use that as a base to jump off of for growth purposes.
Well, thank you. Matt, let me ask you a hypothetical, if I may. If we have a small company that lands a large contract, but early on in performing the large contract, the company already suffered a large loss and the contract hasn't been in place long enough for the small company to actually recognize the profits. They had a lot more costs in the early stages than in the later stages of the project. Is that still potentially a lost profits case?
Yes, potentially. In fact, you said you frame it as a hypothetical, but it brings to mind several cases that we've funded at Cetera over the years, including one that went to trial, and I attended, and the jury ended up being strongly in favor of the plaintiff's position on this, including with respect to the lost profits point, after the fancy firm on the defense side had spent years trying to convince the judge that the damages claims were unduly speculative and unreliable and excludable under Daubert, et cetera, et cetera. So yes, I've seen this scenario play out repeatedly. I think one area that comes to mind is in trade secrets. You might have a key person, a key salesman, a key sort of contract point of contact jump ship from one company to another and take the big new client or imminent client with him or her. And so the small company never gets those huge profits, but it was sort of imminent enough, certain and imminent enough that it's not speculative, and you can kind of see it play out. And we're going to, I think, later talk about disgorgement versus lost profits, and there's certainly a difference, but you can kind of see it play out. Those should have been profits over there at the company that our former executive took our trade secrets to. So yeah, I think that can work for sure. It does, give defense counsel a lot to work with if played correctly, to point out that this company that's never really made much money at all, if any, maybe it's made $1 million or 6 figures of profits, is claiming that if only these terrible things hadn't happened, it was about to make hundreds of millions of dollars. That's always something that defense lawyers can kind of, be dubious about and try to make the fact finder dubious about. But nevertheless, I've seen these cases be successful.
Well, thank you. Megan, we've heard the word cause or causation a few times during the first 25 minutes of our program here today. And so from a damages perspective, how do you narrow in on what causal factor or factors you should be measuring damages from and eliminate other potential causes of lower or lost profits?
Well, essentially, you just got to look at the scenario and question what other potential impacts could have had some kind of play in this outcome. And that could be industry, performance. It could be overall economic performance. Maybe the interest rates spiked, and all of a sudden you're not accounting for the fact that the interest expense was a lot higher in damage period than it was in prior periods, and you haven't eliminated that as a potential, an adjustment to your damages. You have to just think about everything that the rebuttal expert is going to point to and say, well, who's to say that this even could have occurred? And then show that you've done the research and put the information in your report that says either I didn't have to adjust for it because I determined it wasn't a material impact, or I did adjust for it and here's how. And a lot of times you need to do a little bit of digging to find what those situations might be. Like, I've had situations where a complaint said one set of facts, but the 30B6 deposition, the business owner testified to something different. So you want to make sure that you're reviewing all of the records and that everything lines up, or that you're relying on the most credible piece of information. Another situation would be where a business owner might say in deposition that they intended to retire in 3 years and they had no succession plan. And yet, you have originally come up with a 5-year damage period until they can fully mitigate. Well, now you've got to reconsider whether that's even feasible.
Let's talk a little about the role of experts. That was one of the 5 items on our list when I introduced us. So Matt, is expert testimony always needed or always useful?
Virtually always. I wouldn't go so far as to say always, but almost always. And if you can afford it, if your client can afford it, I'm tempted to say that you should always get an expert. I remember about it coming out of law school after my first year or so, when I was reflecting on things that I had no idea about in the practice of law, having done about a year of litigation. The number one item was the ubiquitousness of experts in litigation. I had no idea. And I think most people don't realize what an important role experts play in litigation in America. The other thing was how many binders were involved, but that may be obsolete now. I'm not sure that there's many binders in law firms as there were when I came out of law school. But so almost always, especially if you can afford it. I have seen cases and been connected to cases where the math is so simple. You have the clearest financial statements, revenue records, cost statements, and you have a very good witness at the plaintiff company who's financially sophisticated and thus can explain to the fact finder the necessary math and stand up against cross-examination or attempts to poke holes. But that's very, very rare. I'm strongly in favor of engaging experts early and often. In a perfect world, plaintiffs would engage experts at the beginning of cases or even before they file cases, always. Here at Statera, as a commercial litigation funder, I think probably the hardest thing that we do is trying to size up damages early on in a case. And at the risk of offending some of our audience, but pointing a finger at myself as well, lawyers aren't very good at this. Plaintiffs always have outsized expectations almost always, about what their damages are going to be. And lawyers typically aren't great at doing sophisticated and sober damages analyses. So the sooner that you have an expert providing some rigor and expertise about damages analysis, the better, in my experience. Now, that's usually not the case, either because it's too burdensome and expensive to hire an expert early, or just kind of isn't prioritized by lawyers until you kind of get to that part of the case. But and in some types of cases more than others, you see it. Like in an antitrust case, typically when those come in the door, an expert is already the lawyers have already consulted with or engaged an expert, and sometimes. But yeah, I think experts are almost necessary anytime that you want to prove up damages, let alone any sort of sophisticated commercial complex litigation damages, especially lost profit damages.
Well, thank you. So Nancy, turning to you from the business litigator perspective, the dispute resolution process obviously could vary. Like Matt said, maybe we're in a situation where there hasn't been a lawsuit filed, or maybe not an arbitration claim, but once they file some sort of claim or lawsuit, it could be arbitration, it could be litigation. Some of these get resolved in months, some of these get resolved over a period of years. So when should the client be considering retaining the expert, and what kind of tasks would the expert likely be most helpful in during the process?
I agree with Matt that, certainly earlier the better. Early on in the discovery phase, that expert could be helpful in helping the party assess what's needed to demonstrate the loss of profits with certainty. And they could be helpful throughout the discovery process, determining what documents and information should be requested and preserved. And also in, requesting and analyzing information, financial information, technical information, and also with help calculating damages, as Matt stated.
Yeah, that's a really good point about discovery, especially in highly complex cases. It's so valuable to have an expert guiding the discovery requests and processes. And then also, another virtue that I didn't hit on in my answer is, great experts like Megan and John, the kinds of experts that serious lawyers hire to do serious cases, have made a living, have made it their business to be able to explain complicated matters very clearly to fact finders, whether it's a judge or a jury, to make the math simple, or at least to make the results of the math simple, or the financial analysis simple, in a way that seems authoritative. And even if you have an in-house person who's has an accounting or financial background who can do the math, they almost certainly lack the sort of courtroom presence to be able to explain it and to be able to sort of put it up on a platter for the jury or the judge to take and put into their decision. So experts have an enormous amount of value across all, and also, sometimes they can usefully help calibrate uh, a claimant's expectations around settlement. They can also be helpful in settlement, mediations, what have you. If you go into a mediation, having had an expert analyze damages on both sides, you're probably more likely to get traction than if you're both just making it up or doing back of the envelope.
Yeah, if I could add, Matt, to your earlier point, when you come into the case, that a lot of times the damaged party doesn't have a really good idea of what the damages are, and sometimes they are inflated. And when you talk about early intervention of an expert, one of the major benefits is that it does help to educate the client on how this calculation is going to work, and that there's only so far it can even go. Even if discovery it hasn't occurred yet, you can create some sort of hypothetical scenario calculations that really help poise everybody to go into those settlement discussions with better information and hopefully get things resolved faster.
Well, thank you. Megan, we've been using the word expert a lot. So is there expertise or credentials or professional standards that an expert brings or uses to a particular case that involves lost profits?
Yeah, there are all three, and they're all kind of different. I mean, for an expert to be qualified to testify, they have to have knowledge, skill, experience, training, or education, I believe, is the standard. And it can be some, all, or a couple of those. It depends on the expert and the matter that they're testifying about. But for valuation and damages, most likely there are going to be credentials, including a CPA. If the case involves GAAP compliance, for example, then you want to find the right expert that has experience in, is really well versed in GAAP. If it's a valuation or a diminution of value, or even lost profits, and sometimes you don't know going into it whether it's going to be lost profits or diminution, then you're probably going to be looking for somebody with valuation credentials. So that's the ASA, CVA. The AICPA also has a valuation credential that they offer. And each of those credentialing organizations has standards that they require those individuals to follow. So that just sort of sets the minimum threshold for their experience level. But normally you would look to the amount of testimony and the specific types of cases that the individual has worked on, because having a wide range of cases can be a benefit. You can kind of glean information out of documents and scenarios and find other applicable methods and information sources than you might otherwise if you only ever did one type of analysis. So it really just depends on the case and the circumstances.
Megan, can I ask you a question? Something that sort of an area of this that I'm still sort of trying to master, that you've hit on, authoritatively a couple times already in this call. So you described earlier sort of when to use lost profits versus when to use destruction of the business, right? And it's like, if the business is destroyed, then it's sort of lost profits projected forward because you're never gonna recover, right?
Mm-hmm.
And you were talking about avoiding double counting. And that last answer, you used the phrase diminution damages. And I wonder is that a third kind of damages, different than lost profits and different than
Yeah, that's exactly what it is. Diminution. The value of the company is impaired. You don't ever expect that it's going to recover to the point it would have previously, but it's still alive. So maybe they had to strip out a couple of components of operations or something like that, but they've, reduced their size and continued to move forward. And, as part of mitigation, that's one of the potential options to cut your losses and keep operating. But it is related to destruction of value, but it's just, the company's still there. It's just not in its full form.
So is it in your experience, is that a situation where an expert might sort of calculate lost profits during a, defined period and also calculate, the supposed diminution in value of the business and provide both, or whichever one is higher? Is that sort of a strategic dynamic there?
Well, I don't know that it would be whatever's higher. I mean, if you were going to look at both of them, it would be, like I was saying before, just as a way of reasonableness checking your calculations and making sure that you're kind of on the same page, even if you run the calculation a couple of different ways. But I would think that lost profits and diminution would typically not both be included in a claim, because you can just measure the diminution from the beginning of the period instead of having two separate periods of lost profits and destruction. Does that answer your question?
Yes, it does. But I may call you someday to get you to help me sort through a situation, because I see this, as I say, in litigation finance, we get sort of, for lack of a better word, pitched on cases. And as I say, the damages part is very difficult. And sometimes I'll see lost profits, and sometimes they'll say, we lost $50 million, as Nancy was explaining, revenue minus costs. Although parenthetically, it's a little bit shocking how often people pitch us damages based on revenue, and we have to ask what the costs are. That happens more than you would expect. So they could pitch loss, but other times it's an indistinguishable case, and they say, our business before this thing happened was worth 50 million bucks, and then afterwards it was worth only 10 million bucks. So the damages are 40 million. And at times it's not clear to me why a loss profit analysis would be appropriate in case A and a diminution in value of the business would be appropriate in case B.
Well, and it's also about the available data. If they actually had a business valuation performed right before it happened, that might be your best evidence.
Yep. But isn't it, not to get too eggheady about this, but isn't the value of a business sort of a function of its profitability anyway? Shouldn't it sort of, to use your word, triangulate to the same place if you're valuing a business correctly?
That's right.
Well, let me follow up a little bit here, and I'm ask both Megan and Nancy to weigh in. We heard about expertise. We heard about professional standards. What about standards from the court? Because sometimes we hear that experts occasionally have either not been allowed to testify or been limited on their testimony. And so that suggests that maybe there's some standards that the courts are applying to avoid maybe what Matt was mentioning. A lot of defendants like to throw out that allegedly the plaintiff's claim is speculative. So are there some court or legal standards, Megan, that as an expert that are considered? And then Nancy, we're going to ask you to expand upon that from a legal perspective.
Yeah, from my perspective, my opinions have to be relevant to the case at hand. They've got to be helpful to the trier of fact. They have to be based on sufficient information, and they have to be based on reliable methodologies that are reliably applied. That's kind of strange wording, but it's not mine, it's theirs.
So Nancy, are the rules the same for every court and jurisdiction across the country, or do they vary on the requirements for expert testimony to be admitted?
Yeah, the rules are this generally the same, but the methodology that's applied can vary based on the facts and circumstances of the case. So, there's a number of different methodologies that courts use. One of them being before and after approach, which is you estimate the lost profits based on the plaintiff's sales and trends before the damaging event, compared with a projection of the sales that would have been achieved but for the event, reduced by the incremental costs. So this methodology is appropriate where there's reliable historical data. There's growth trends. The growth trends are steady and predictable and in relatively stable economic environments. So this is generally courts will favor financial projections that are based on past results. But as we discussed earlier, they're not always. So in other situations, courts may use the yardstick approach, which estimates the plaintiff's profits based on a comparable company, division, or industry benchmarks that were not affected by the damaging event. So this may be more useful for newly established firms or if the market conditions have changed subsequent to the damages event date. An additional methodology is the sales projection approach. This one utilizes company-specific forecasts prepared in the ordinary course of business or for some purpose other than the litigation. So as I'm sure you can imagine, the issue with this approach is that it can appear self-serving if it's unsupported by outside validation or if the projections were prepared after the harmful event. And then finally, there's the market share approach, which calculates the lost profits based on the difference between the plaintiff's but for market share and its market share following the damaging act. This is generally appropriate when reliable market share data exists and the plaintiff's products or services fit within a defined market. It's less helpful if it's a niche or fragmented industry.
Well, thank you. As we move into our final 12 or 13 minutes of our hour here, Matt, you'd mentioned a little earlier that you had some observations about the age or stage of the business and how that might affect a lost profits claim. So would you like to share some thoughts about how the approach might be tailored or maybe different for a relatively new or unestablished business?
Yeah, I mean, in my experience, it's kind of rare that you have, maybe it's just Cetera's sort of niche in the market is to do not huge cases, but typically cases where a small business has been harmed by a bigger business. So in my experience, it's kind of rare where you have a sort of stable track record, a business that's just plugging along, making consistent profits, consistent revenue. It's sort of mature and consistent and stable. In my experience, the cases are typically small companies that are on the rise, or at least claim that they're about to be on the rise. Now, I can't tell you how many cases sort of we don't fund or don't even really spend much time on because they come in the door and it's a startup telling us that they were going to be the next Google if only they hadn't been, screwed over, which truly is speculative. It's, if our package had been delivered on time, then X, Y, and Z were going to happen, and then we were going to conquer the world, and we were going to be $1 billion company. We were on our way to being a unicorn, and then we got screwed over. So young companies claiming sort of consequential damages, dramatic consequential damages, dramatic lost profits is very common. and very challenging, frankly. And as I said earlier, good defense lawyers will make that one of their, in my experience, one of their main themes. It's just sort of the sanity check. Do we really believe that these guys in their garage who had never made a profit were actually going to be making $100 million if it weren't for what my client did? Like, just does that even pass the sort of does that even make sense to you? Does that seem plausible to you? It's a very common dynamic, but as Megan and Nancy both sort of explained, there are sound, acceptable approaches. Like I think built within Nancy's answer just now, there's a few examples of ways that even small companies can pass can get over the hurdle of Daubert or Rule 702 or what have you, improving lost profits even though they're young, maybe even unprofitable. Uh, that's tricky. That's another good topic someday, Megan, when it's, if you have an unprofitable company, but it's worth $100 million because it's, AI, right? I mean, is NVIDIA even profitable yet? What are NVIDIA's lost profits? Yeah, I guess NVIDIA is profitable. They're making like $40 billion. But a lot of spaces, a lot of the most valuable companies on the market these days aren't actually profitable. So in any event, whether a business is mature and has a track record or is young and growing makes a huge difference. It's much harder for the young and growing company, but with the right evidence, like contemporaneous projections, like third-party validation of contemporaneous projections, you can be successful with a lost profit claim even for an immature company.
Well, thank you. Megan, as we come down to the last 8 or 9 minutes here, wanted to pick up on a few things that were discussed earlier. Matt had mentioned earlier costs, that sometimes the preliminary damages calculations that are asserted that he sees are only looking at the revenue side. So how does the analysis from the expert perspective take into account costs?
That actually speaks to Matt's point just now too, because those companies that aren't earning a net profit could actually still have lost profits because it is only the incremental costs that are reduced for establishing lost profits. So the incremental costs would be any direct costs necessary to produce that additional dollar of revenue, or if you've established that there's 100 million in revenue that's been lost over the next 5 years, then what are the costs that won't have to be incurred by the company because they are not going to be generating that revenue?
Well, thank you. So Nancy, in the last few minutes here, we may do you and we may do 1 or 2 other questions depending on the amount of time that's left. We're down to about 7 or 8 minutes, but we wanted to ask you about the other side of this, defending a lost profits case. We heard a lot from the plaintiff's perspective. We learned a lot about the plaintiff's perspective. We learned a lot about some of the potential challenges, but specifically from the defense perspective in defending a lost profits case. What are some of the classic ways that are used to attempt to defend against or attack a lost profits analysis?
So to start, I'll note that plaintiffs are expected to mitigate damages where possible. So if they fail to mitigate, it could reduce their claim. Some other defense strategies could be challenging the expert. You challenge them on, I'm sure Megan, never happens to Megan, but challenge them on their qualifications or their lack of independence. If they overstep on their opinion or expertise, and any failure to comply with Rule 26 requirements. You can also challenge the data or the assumptions, as I discussed earlier with the Capital Metro case. And you can also challenge the methodology, failure to follow accepted methodologies or discount to present value. And I guess some other, quickly, some other defenses could be lack of causation. So failure to show a reasonable connection between the act and the damage, or a lack of foreseeability. So lost profits must be shown to have been factually and legally caused by and a reasonably foreseeable result of the defendant's conduct. And our big theme of today, the speculative nature of the claim.
I would add one
Thank,
more, John, that could be a whole separate seminar and is incredibly common in my experience, which is contracts, particularly when the one side has more bargaining power and ends up being the defendant, often state that consequential damages aren't recoverable. And that always engenders this whole fight about whether lost profits are consequential damages. And in fact, there's this sort of contract nuance where they'll say indirect or consequential damages aren't recoverable, and then parens such as XYZ, lost profits, ABC. Lost profits will be in the list of consequential damages, but that doesn't stop most plaintiffs because there is a legitimate argument that lost profits aren't always indirect or consequential, that they are, I mean, maybe they're always consequential, but maybe not. I don't know if Megan has a view, but there's a strong argument oftentimes that lost profits are direct damages, even though they are sometimes used as one of the examples of indirect damages in the contract. So there's often a fight about whether the contract even permits lost profits damages because of that clause.
well, thank you. Megan, Matt earlier brought up the point about there's something else called disgorgement damages. And from your perspective, is that a category of lost profits, or is that something different?
No, it's different. It's an alternative in some cases, and it can also be additive in some cases. So certain IP litigation, for example, if there's an infringement, you can calculate your own direct lost profits damages. And then on top of that, anything over and above that amount that the defendant earned as a result of taking your intellectual property, you can get that as well. And a lot of times in that case, you would only bother with doing the disgorgement calculation because frankly, the data is easier to obtain because it's actually occurred. So long as you have ready access to the information.
So what type of cases might that occur in, like trade secrets or
Trademark infringement?
Theft of, like you're saying, intellectual property, or maybe employee raiding, taking of key employees and violating some agreements or committing a tort doing that?
Copyright infringement, I believe, too.
Okay.
That's where I've dealt with it the most.
And Nancy, from the expert's perspective, we've been hearing that there's been an increase in the number of trade secrets cases that involve damages filed recently. What's your experience been in that area recently?
I honestly haven't had much experience in the trade secrets realm. Not sure if others can weigh in.
Yeah, I think we've seen that anecdotally, and there's a story being told in the trade press that because patent cases became more difficult for several years there, that litigation sort of morphed into trade secret litigation, and it became more difficult because of IPRs and a arguably sort of skeptical federal circuit, and so that led to more trade secret cases, which avoid those pitfalls. And anecdotally, I think we've seen that. And in fact, I think that Lex Machina released a report showing it empirically that there's more trade secret litigation than ever. And yeah, that's one where I think the explicit measures of damages can either be lost profits or disgorgement. I think one interesting dynamic in that context is when those two are dramatically mismatched, that creates I think some problems that a plaintiff has to work through, either as a legal matter, sort of rigorous damages expert matter, or just a common sense sort of equities out in front of the jury matter. You know, it's like their actual lost profits were 500 grand, but they're claiming that they're owed $80 million because that's how much Apple made. Maybe that works, maybe it doesn't. It's an interesting dynamic.
Well, thank you. So at this point, I'm going to first thank the most important people. That's our audience. Whether you're listening live today on February 26th, when we are premiering this program, or whether you're listening on demand over the course of the next year, we are glad you are here. On behalf of all of our speakers, we invite you to reach out to any of us if you'd like. Our emails are in the slide deck if you have any follow-up questions. And then on behalf of Financial Poison, our audience, a little clap out to our panel, Megan and Nancy and Matt. We very much appreciate your insights and your time. Thank you for joining us. And thank you to everyone. And this closes our program. Take care. And we'll see you next time on a Financial Poise program. Bye-bye.
Thank you.
Thank you, John.